number 63, the people of the state of New York versus Tyrone, Wortham. Counsel?
May it please the court, my name is Angie Louie for the appellant Tyrone, Wortham. May I have 2 minutes for rebuttal, please?
You may.
Your Honors, under this court's precedent in Williams and Foster Bay, the conviction must be reversed and a new trial ordered since the court below erred in the presentation of the FST evidence without a Fry hearing. The error was not harmless, as there was only circumstantial evidence that Mr. Wortham possessed the contraband, and this court must remand for a new trial.
Counsel, if we agree with you, do we have to answer any of the other claims raised?
Yes, Your Honor. At the new trial, the court must also suppress the unmirandized statements that Mr. Wortham gave the officer during the execution of the search warrant, essentially stating that his children's mother allowed him to live in the apartment. Although the prosecution claims that these officers' questions were booking questions that are an exception to Miranda, first of all, they were not booking questions under Rodney or Munoz, because this was not done.
Tell me why you say that. Why wouldn't Rodney apply here?
Rodney does apply, and it doesn't apply for 2 reasons. It does apply because the officer should have known that the question, where do you live, when they were executing.
Well, that's clearly an administrative question, where you live. It's a standard question they give to everybody. And they hadn't searched the apartment yet, so certainly we wouldn't have to look to any subjective intent of the officer, but objectively, they hadn't done any search. It seems that while the question itself is covered by Miranda, I agree with you about that, and that's what I think the law says. The exception here, because of the administrative concerns that the officer was dealing with, and it was before the search, I'm wondering why the exception wouldn't apply.
Well, this would be an expansion of what Munoz and Rodney allows, which is for booking questions in the precinct for the administration of court purposes. Here, this was basically done for the convenience of the police officers.
So, counsel, would your rule then be any question in this setting is no good? Doesn't matter what the question is, really, because it's custodial and you haven't been Mirandized.
No, Your Honor, but here, where there is a reasonable expectation that it was reasonably likely for the appellant to make an incriminating response because of the circumstances of this case, these questions were definitely improper.
It seems to me, though, you're confusing 2 things, that there's a question of whether this is a proper place and time to do this type of process. That's one. And if the answer to that is yes, then I think we treat it the same as we would booking. If the answer to that is no, then none of these questions are any good, right? Because once it's really an administrative process that we've accepted can have certain pedigree questions, then I think, the questions are the same, Because what if, in this setting, you think this defendant may be using a name or an alias, but you're going to ask everyone their names. They're in the apartment, you're going to ask them names. You ask the name, the defendant gives the name, and it turns out, yes, you can use that name and get other evidence. Is that good or not good?
No, Your Honor, that's not good, because under Rodney and under Munoz, and 8 circuits agree that the standard is to look objectively, not whether the question was designed to elicit an incriminating response, but under the circumstances. And here, under the circumstances, the officers should have known that the question, where do you live, while they were executing a search warrant, would reasonably likely elicit an incriminating response.
But that would be the same in my hypothetical, right, with a name.
Yes, Your Honor.
So anything that comes from that, asking that person a name who's in that setting that we just described, this setting in this case, would be suppressed.
Yes, Your Honor. Actually, under Rodney and under this court's precedent. And it actually makes sense.
Do you think that's what Rodney says?
Yes, Your Honor, it does. I mean, I think Rodney purports to 2 things. First is that this must be a true booking situation. And here, I would argue that this was not a booking situation. This was, I mean, the NYPD
Only
is-
because it was at the home? If it was at the station house, it would have been?
Well, even if it had been at the station house, and if pressed, I would answer, even at the station house, this question would have been improper, because they had already found the contraband, and the question, where do you live, actually goes towards an element, constructive possession.
Does that change the nature of it? The question was before any search had taken place. We agree on that, right?
Yes.
Okay. So doesn't that change the nature of the question and the effect of the pedigree question?
No, actually, Your Honor, it kind of makes it worse, because, the search warrant, and the police officers knew that they were going in for a search warrant, and they knew that they were probably likely to find contraband.
So
in
your
the
theory
apartment.
is that this allows them to establish who's connected to the contraband by asking this question under the guise, I put in quotation marks, of a pedigree question.
Yes, Your Honor.
Of course, these 5 questions that were asked, they're the same questions asked of everybody, and they're the same questions that are always asked.
And it's improper under a search warrant because you have to look at the circumstances of the situation. And
I'm not sure I
furthermore,
agree with you. I do understand it. I understand what you're saying. I'm not sure I agree with it, but I do understand what you're
What
saying.
would the officer do in my hypothetical? So then he just doesn't ask your name?
Your Honor, under those circumstances, if they knew that, for example, the search warrant was for identity fraud and they were looking for identity fraud, in that instance, I would argue that no, the officer couldn't ask the name. But here, where they were looking for contraband.
And that would even be true at booking? You couldn't ask the name?
Well, that's not the situation here because they
No,
were
I know it's
at
not,
the
but
precinct.
hypothetically.
Hypothetically, if pressed, yes, Your Honor, they would not be able to do that unless they had Mirandized.
So you just booked them under John Doe or something?
Or they could have Mirandized the defendant when they.
And what if they
had-
say, I'm not talking?
Then they have the right to invoke their Fifth Amendment right against self-incrimination. And so that's also why, under these circumstances, especially because this was not a booking and the police were using these forms as a guise to do investigation, the questions were improper and the statements must
So
be.
you keep saying, I'm sorry, you keep saying under the circumstances, and one of the circumstances that seem to me to be important is the warrant itself. But I've looked through, and you've made some characterizations about what the warrant was for, but I've looked through the record and I can't find it. I can't find the warrant or the supporting affidavit. Do you know what it said? Do you
Yes,
know,
Your
for
Honor.
example, if any of the supporting materials attached to it named Mr. Wortham?
Well, one of the reasons why the warrant wasn't in the record was because a lot of the information from the warrant was suppressed and not allowed as evidence in trial. But the warrant basically allowed the officers to enter to look for contraband. It wasn't a specific warrant for Mr. Wortham himself, but it was for a search of the apartment for the contraband. And so they knew that when they went in that they were probably likely going to find contraband. And so that question of where do you live, especially because it was before they found anything, and it was during the chaotic moments of when they first entered with a no-knock search warrant, was improper.
Where in the record of the suppression hearing is it demonstrated that the defendant was actually under arrest?
The officer testified that he was not under arrest, but he was definitely in custody. He was handcuffed and he was surrounded by the officers almost immediately after they entered the apartment. Mr. Wortham was found with his 2 children. He did not struggle or anything. And in the suppression hearing, it wasn't until they had already brought Mr. Wortham back to the precinct that the officer testified he got a phone call from the officer at the scene that contraband was found.
And just going back to something you said briefly before, that the officers cuffed him for their convenience?
Yes,
What does that mean?
they
You
say
said-
that that's procedure. It's for their safety and their convenience. They cuff all adults found in the premises of a.
And is the process also to satisfy the importance of documenting enforcement actions that actually detain people? and having the police department maintain a record of those incidents?
Well, yes, Your Honor, but, the booking exception is only for the purpose of court administration. I mean, the Sixth Circuit has opined that very rarely will the booking exception apply outside of the precinct when you actually need to book someone. The NYPD is using...
Well, we're not talking about booking him though, right?
No, because this was not a true booking situation.
Okay, thank you, counsel.
Thank you.
Counsel?
Thank you, Chief Judge DeFiore, and may it please the court, David Cohn for the people. I just want to start very quickly with the FST issue. And the first point I would like to note is that if this court agrees with the defense in this case that a Frye hearing is necessary, the proper remedy would not be a reversal of the conviction. It would be a remittal to the lower court for a Frye hearing, and the reversal would only be necessary if it's determined that FST doesn't meet the Frye standard, that the evidence should have been excluded from the trial. So if this court does believe a hearing is necessary, remittal would be the proper remedy. Beyond that, we do submit that this case is different from Williams and Foster Bay in several important respects. To begin, in Williams and Foster Bay, there was not much of a record made by the people about the science behind FST and LCN. Both of those cases dealt not just with FST, but with the combination of FST and LCN low copy number DNA testing, which was also controversial at the time. So there was more at issue in the Frye hearing in those cases. And also in those cases, the people made only very thin records of the scientific basis for either FST or LCN testing. Here, the people made a very robust scientific record of why FST was generally accepted, and the defense papers did not really join issue with the science that was presented by the people in this case. What the defense papers argued was that the OCME analysts exercised too much discretion in plugging the numbers into the computer software. They talked about the calculations, basically the counting of allelic drop-ins and dropouts, and they disputed whether Bayesian statistics could be used in this type of situation. But those aren't questions for a Frye judge. A Frye judge is supposed
I think we've already said that they are.
Well, Your Honor, I submit that there was a more robust scientific debate in Williams and in Foster Bay. In Williams, for instance, the defense...
Right, but that doesn't obviate the need. You may be right about that. I won't argue. You know better than I do, actually. But it seems that you're still required to hold the Frye hearing here. I don't think that there's much of a way around that. I think the more compelling question is how the pedigree exception is dealt with, and whether or not the question of where you live it creates a situation where it's reasonably likely to evoke an incriminating response in these circumstances.
Your Honor, so to begin with the pedigree issue,
Yeah.
First, we should make clear, as I believe some of the questions from this court recognized, what happened here was a true administrative questioning. There's testimony in the record that the police...
Let me ask you, let's take a step back. What's the purpose of the question?
The purpose of the questioning is to document, and the police officer explained this, or the detective explained this at the hearing, to document every person who was in custody during a search of a premises. Is for the police record-keeping purposes. And by the way, this serves an important administrative purpose, not just so the police know who they have in custody, but also for the purpose of police accountability, that we know who the police encountered anytime they went into an apartment.
But what is the question where you live, counsel? I'm sorry, I'm on the screen. What does the question where you live have to do with that?
Oh, sorry, Judge Rivera.
That's all right.
The question of where you live is a routine administrative question, and it allows the police to know who they were dealing with. If you just get a name, you don't necessarily, there could be a million John Does, right? So you don't...
So let me ask you this. What would the officers have done if he says, I'm not going to speak to you, I have nothing to say? What would they do?
What would they do? Well,
Yes.
Under under the Muniz standard, this is not a situation where a defendant necessarily has the right to invoke their right to remain silent, which would apply to most
Well,
custodial
no,
interrogation.
I'm sorry to interrupt. I understand the question about the right. I'm just saying in practice, I'm sure there are people who say, I'm not going to talk to you. So if he said, I'm not going to talk to you, what would the officer have done?
Well, I imagine at that point the officer, and I don't know from the record exactly what the officer would have done, but I imagine the officer probably would have handcuffed the defendant for the safety purposes like they do, with every person they encounter while executing a search warrant, would have probably tried to explain to them that these are administrative questions that they simply ask everyone. I'm not sure what else they could have done beyond that if somebody stands mute.
But don't you start with the premise that, and this is, I think, where there's some confusion in the law. In researching the case, it struck me that I think the analytical mistake sometimes that is made here is that this is a custodial interrogation. I think Judge Rivera is directly on point for that. This is a custodial investigation, or interrogation, excuse me. Miranda does apply here. The only reason that this question is allowed is because the Supreme Court that says there's an exception to pedigree questions, and they haven't limited to contact. But otherwise, they do have a right to invoke Miranda. But for these standard questions that are necessary for purely administrative purposes, they can be asked.
Right, that is exactly, Your Honor. That is the pedigree exception to Miranda. And what the Supreme Court said...
In other words, it's not a question, just to clarify, it's not a question that's likely to invoke an incriminating response, period. That's when, no, that's only, we start with the premise that Miranda applies, and you cannot ask that question. And it's only that rule only applies subsequent to when you look at the nature of the question, making sure that it falls within that exception, and it is directly related to an administrative purpose.
Your Honor, Judge Fay, I agree. And I agree that there is some confusion in the law on this as well, or at least some confusion perhaps in the discussion.
Counsel, I'd like to talk about that, right?
Yes.
So there's a lot of confusion, it seems to me, in this law, which isn't serving anyone particularly well. There's a plurality. We have a few decisions, the appellate divisions. What would be the rule you would apply?
So, Your Honor, I would apply the Muniz rule, which is what I believe this court meant to adopt in Rodney. The Muniz rule is quite clear. As Judge Fay said, in Muniz, the Supreme Court said when there are pedigree questions asked at the precinct, they could very well be custodial interrogation, right? And under Innis, the standard for custodial interrogation is a question that's reasonably likely to elicit an incriminating response. A name could be incriminating in all kinds of ways, like somebody had an alias, maybe there's just some way their name connects them to a crime. Their address could be incriminating in a lot of ways. There are lots of cases where contraband is recovered from a person's residence. But the Supreme Court said that regardless of the fact that these questions could be likely to elicit an incriminating response, if they are reasonably related to the administrative concerns of the police, they are exempt from the Miranda rule as an exception, with one caveat, which is footnote 14 of the Muniz decision, which is if they are designed to elicit an incriminating response.
So let's talk about designed to elicit. I think that causes confusion. I mean, so reasonably likely designed to elicit. Designed to elicit, like you were just saying, your name, your address can be incriminating, depending on the case. But is the question designed to elicit, is it the difference between the question itself, where do you live, or the design in asking the question? What do you think?
I think it has to do with the purpose for which the question is being asked. Now, that may or may not be the officer's subjective purpose, and I'm thinking at the moment I want to get this information from this defendant for incriminating purposes. There actually are some federal cases that say if the officer goes in with that sort of objective, then maybe the pedigree exception won't apply in that situation. That's not what happened here. The suppression court made a factual finding that there was no agenda. This officer had no ulterior motive in asking this question.
That's a very hard standard, though, right? I mean, why isn't it just designed in the question itself? So if I ask you, in a pedigree context, how much cash do you have? Maybe I designed that question here to elicit a response that's going to incriminate you. But design, I don't see how what's your name can ever be a question designed in itself to elicit incrimination.
Right, and Your Honor, certainly in this context, we submit that the question, what's your address, and it's not the only question that was asked. It's asked along with name, address, various general demographic pedigree information.
New York, what's the population now?
Of New York, almost 20 million, right?
Yeah, so how many people are arrested in a year? I don't know the number, but there's a lot of people that have to be processed. So I'm assuming that once somebody's processed, they want to get out, they want bail to be set on them, they want their family to be able to find out where they are. So we have to actually look at the question objectively to see if it meets those administrative purposes. Also, with the other consequences in mind, but I don't see anything in the question itself that's different from any other question asked in any other booking in the city of New York. In other words, that it has a specific design. And it's a subtle problem, though, because clearly the answer to this question can be incriminating. And
Right.
I recognize that.
Right, and that is what the Supreme Court recognized in Muniz. that
Okay,
the-
so counsel, I'm sorry to interrupt you again, but I just want to drill down a little bit on the way you're articulating this rule. I'm going to read you from Rodney, and I'd like you to explain how the way you've articulated the rule is demonstrated by what I'm about to quote. Similarly, the people may not rely on the pedigree exception if the questions, though facially appropriate, are likely to elicit incriminating admissions because of the circumstances of the particular case. I don't see the word design in there anywhere, so I'm a little bit confused why you are limiting your rule to design when obviously the court did not. And by the way, this quotation is taken full paragraph explaining other circumstances under which the pedigree exception will not apply.
Right, and Your Honor, this is the confusion in Rodney, and I do think that there is some confusion from Rodney because Rodney says different things in different places in the opinion. This particular passage that you mentioned is actually from a discussion not about Miranda, but about 71030, the notice requirement under the statute. The preceding sentence says statements made in response to questions which are not directed solely to administrative concerns are subject to the requirements of CPL 71030. Now, I understand why there might be a broader standard under 71030 because we're talking about when does the defendant get notice of a statement. And we certainly want there to be a broader disclosure rule where a defendant gets more notice of statements that might be suppressible. But when you're talking about what Muni is...
But the sentence that I read, yes, you're not incorrect that at the top of the paragraph, the court cites CPL 710.30. I'm not, you're absolutely right about that. But what I just quoted, the citation is Muniz and Innes.
Right, and I have to say, this is where some confusion does arise because...
What's the confusion?
Okay.
The sentence is very clear. The people cannot use the exception. If the question facially appropriate, I think everyone is with you asking address, name, seems face quite appropriate and to deal with an administrative situation. But then it says are likely to elicit incriminating admissions, not as a general matter, because you would be right about that. We can't say sort of anywhere, writ large. No, it says because of the circumstances of the particular case. So I think this is what defendant's point is about that given these circumstances, they are there for a search warrant that has to do with possessory crimes. He is there, they handcuff him, and they ask a question that will connect him to what they anticipate they're going to find there. I would assume that an officer anticipates the warrant is good and based on a legal justification for going into some house to look for drugs, guns, contraband, paraphernalia, whatever they're looking for, but evidence of criminal activity, right?
Judge, may I answer?
Counsel, yes, I know what you're going to ask. Because the technology was a little spotty there, did you understand the full scope of that
Yes.
question? Okay.
I
thank you.
believe I did, and Judge Rivera, please correct me if I misunderstand the question. So the first point of confusion that arises from this quote on Rodney is that it's cited to Muniz footnote 14. Well, Muniz footnote 14 does not say that. Muniz footnote 14, if you read Muniz, Muniz says that, yes, we understand that these booking or pedigree questions might be likely to elicit an incriminating response, but still there's an exception to the Miranda requirement as long as they're reasonably related to administrative concerns, except, as the Supreme Court noted in footnote 14, except if they are designed to elicit an incriminating response. So this court did not correctly describe the footnote 14 in Muniz, and the other cases that it cites, now citing Rhode Island v. Innis also was confusing to me because Rhode Island v. Innis is the standard for interrogation. Interrogation, of course, is a prerequisite to the Miranda rule, but Muniz says even if there is custodial interrogation, and as Judge Fahey mentioned, even if the Miranda rule applies, there is this pedigree exception for routine administrative questions. Then the other cases that are cited later on in the paragraph, Doe and Pera, and Antonio, these are situations where either objectively or subjectively the questions were designed to elicit an incriminating response. So I think that the only way to coherently read the Rodney opinion, and Rodney does later on in the opinion mention the design to elicit incriminating response language from Muniz. So I think the only way to coherently read the opinion is that in Rodney, this court was trying to adopt the Muniz standard, but this was just a line which perhaps should not have been written that way.
Counsel, do you think if they had asked what bedroom was his, that would have taken it out of the scope of what's reasonably related to police administration?
Judge Singas, I do believe that question goes beyond what we normally consider pedigree questions. And so that could very well be considered an investigatory question as opposed to an administrative question. So I could see in that situation a court holding that the Miranda requirement is triggered by a question specifically like that, especially. Now, of course, it might not be so relevant in every situation, but in this situation, if, for instance, the police officer knew there was contraband in the bedroom and then asked the defendant, what bedroom do you live in? That definitely seems like an investigatory question. I suppose it could be an innocuous question in some circumstances. Let's say there were roommates and the police just didn't want to search the room of someone who wasn't the target of a search warrant. They might say, is that your room, right? For an administrative reason. It might just depend on the circumstances.
Thank you, counsel. Ms. Louie?
Thank you.
You're welcome.
Your Honors, this was not a true booking exception, and the prosecution is using the booking exception as an end run around Miranda in this case. They've taken it out of the context of what this court recognizes. You know, they're saying that the police should be able to go in under a search warrant and for administrative purposes, or rather the convenience of the police, ask these questions which are booking or pedigree questions.
Okay, but counsel, can you address, you heard the line of questioning to the assistant district attorney regarding what Rodney states and whether or not it's by design. Can you address that point about what is the rule that you get from Rodney?
I think Rodney makes clear that it's the objective standard, that even if a question is facially appropriate, if it's likely to elicit an incriminating admission because of the circumstances of the particular case, then those questions are not appropriate and the statement must be suppressed. You know,
But here's the problem I have there is, even if we objectively apply that, since there hadn't been any search that had taken place yet, in fairness, it seems that even objectively, it doesn't meet that standard.
Well, actually, objectively, it does, because
Okay.
when you think about it,
Tell me how.
right, at the point before the search happened or contraband was found, the police could have just waited. I mean, Mr. Wortham was already handcuffed. He was surrounded by officers. And if contraband had already been found, then objectively, they would have known that the question, where do you live, would likely elicit an incriminating response. But if contraband was not found, and they needed for, as they claim, NYPD purposes for accountability, find out who was in the apartment for later on, right, there would be no question that would likely elicit an incriminating response.
So
Because-
let me ask you this, it's just anecdotally, just a little bit off the track here. My experience is these questions, I think there are 5 components to it, are always asked at every arrest. Is that your experience?
I believe so, yes, Your Honor.
And I'm assuming it's the DA's, I won't ask him that, but I'm assuming he's probably seen more of them than all of us, but, because that's my experience, whenever I've seen this, it's always these same questions. That's why I'm having a difficult time of seeing a design here.
But it's not, the design is only one of the factors that this court should look at.
Of course.
And under these circumstances, the specific circumstance of this case, which was a search warrant, where they knew that they were probably going to find contraband, it was reasonably likely to elicit an incriminating response by asking, where do you live? Because that goes towards the element.
Thank you, counsel.
Thank you.